Hello, I'm Jennifer. Welcome to another episode of Case Brief brought to you by the Missouri Sheriff's Association. Before we get started, I want to remind everyone that this information is for training purposes only and in no way is to be considered legal advice. Today, we focus on an 8th Circuit Court of Appeals case involving entering upon curtilage without a warrant. Our goal is to provide a clear understanding of how such cases unfold. Remember, this content is educational and not legal advice. So let's dive into the details. In United States v. McGhee, the United States Court of Appeals for the 8th Circuit considered the boundaries of the Fourth Amendment regarding the distinction between curtilage and an open field. In this case, the court examined whether law enforcement officers could use their plain view observations of private property as justification to enter and obtain a search warrant. In July 2021, Jalen McGhee and his 6-year-old were shot at while sitting in a parked car. McGhee's child sustained gunshot wounds, so McGhee took him to the hospital. Police officers, unaware of whether anyone had sustained injuries, responded to the 911 calls. At the scene, they found 8 shell casings, a bag of suspected narcotics that was later identified as heroin and fentanyl, and a loose $5 and $1 bill on the street outside McGhee's house. When police approached the house, one officer noticed a door on the side and, for safety reasons, observed the fenced side yard from the front yard. The area was accessible as the fence had been left open, so the side yard, door, deck, and stairs could all be seen. While observing the side yard, the officer noticed that the deck had several spots of blood spatter as well as an unknown white or brown powdery substance, which the officer assumed to be narcotics. Due to the belief that there was an injured shooting victim in the backyard or house, the officer entered the side yard. Concerned that there might be an injured victim in the yard or house, the officer considered entering the area under exigent circumstances. After communicating with a detective at the hospital and confirming the blood was from McGhee's son, the officer decided against a warrantless entry and instead applied for a search warrant, detailing his observations in the application. The search warrant was issued. During the search, officers discovered cocaine base, heroin, and fentanyl. They also found a trail of blood leading into McGhee's bedroom, where they discovered 2 firearms. McGhee was charged with possession with intent to distribute narcotics and as a felon in possession of firearms. In the district court, McGhee moved to suppress the guns and narcotics found in his house, arguing that the search warrant application was based on illegally obtained evidence in violation of his Fourth Amendment rights. The district court rejected this argument. McGhee then appealed to the 8th Circuit Court of Appeals, once again challenging the validity of the search warrant based on illegally obtained evidence, claiming the application was based on a violation of his Fourth Amendment rights. The 8th Circuit Court upheld the district court's decision to deny McGhee's motion to suppress, finding that the officer's initial observations of the side yard from the front yard were lawful, as the area was in plain view and there was an exigent circumstance that justified their further entry. McGhee argued that both the front and fenced side yards were part of the curtilage of his home. Therefore, the viewing of the blood spatter and powdery substance occurred on the curtilage in violation of the Fourth Amendment, since no exigent circumstance existed to justify a warrantless search. The court examined whether the officers entered the curtilage of McGhee's home. The court cited United States v. Dunn, a case where the Supreme Court outlined 4 factors to help determine curtilage. The Dunn factors include how close the area claimed to be curtilage is to the home, whether the area is included within an enclosure surrounding the home, how the area is used, and what steps the resident took to protect the area from passers-by's observations. Applying the Dunn factors in this case, the front yard was not curtilage in the court's assessment. It was unfenced and had a paved route for visitors, exposing it to public view. Therefore, it was deemed an open field for Fourth Amendment purposes. The side yard, however, was directly next to McGhee's house. It was also fenced off, and there were trees and a back fence that further protected the area from observation. Lastly, the area contained items suggesting family use. As such, the side yard met the standard of curtilage. Next, the court analyzed whether the officer's observation of the deck from the front yard constituted a Fourth Amendment violation. Since the fence to the side yard was left open, the deck, blood spatters, and powdery substance were readily visible from the front yard, an open field. Observations made from this lawful vantage point are permissible under the plain view doctrine. Thus, there was no violation of McGhee's rights by observing the evidence in plain sight. The court then considered the exigent circumstances exception. Referring to United States v. Chips, law enforcement is exempt from the warrant requirement in situations where immediate action is necessary, such as the risk of someone's life being in danger. Here, the court concluded that the discovery of shell casings and a visible blood trail reasonably led police to believe someone might need emergency aid, initially satisfying the circumstances necessary to justify an exigent entry. Since the officers did not conduct a warrantless search, the properly applied for warrant was issued based on lawfully observed evidence. Therefore, the court concluded that this rendered the subsequent search lawful and its fruits constitutional. Ultimately, the Eighth Circuit upheld the district court's refusal to suppress the evidence, holding that the initial observations of the side yard from the front yard were permissible and concluding that the exigent circumstances justified entering the side yard given the possible medical emergency. When we examine the rule of law, we find that a warrantless entry is permissible under the Fourth Amendment when officers have probable cause and exigent circumstances make it impracticable to obtain a warrant. But what if the officers create the exigency? The U.S. Supreme Court in Kentucky v. King noted that there is a strong argument to be made that, at least in most circumstances, the exigent circumstances rule should not apply where the police, without a warrant or any legally sound basis for a warrantless entry, threaten that they will enter without permission unless admitted. In King, the Supreme Court held that the exigent circumstances rule applies when the police do not gain entry to premises by means of an actual or threatened violation of the Fourth Amendment. Thank you for joining us in this episode of Case Brief. We hope this analysis provided valuable insights into entering upon curtilage without a warrant. We want to thank Eric Daigle and the DLG Learning Center for contributing to today's brief. Stay tuned for more episodes brought to you by the Missouri Sheriff's Association. If you enjoyed this content, please like and subscribe. We look forward to bringing you more informative episodes in the future.